Go to our Lion Legal channel. Make sure to like, comment, and subscribe. Today we're going to be talking about an individual at the Pride event in Seattle. Now, the Pride event is synonymous with people showing exuberance and a lot of passion for their ideals. However, there's one particular individual who has done something incredibly controversial and might have done something illegal. So essentially what he did was twerk in front of what appears to be underage people, kids. And the question is, did he commit a crime? Well, it looks like he might have, because under the Seattle Revised Code, section 9A .88.010, indecent exposure is criminalized, and indecent exposure is defined as a person is guilty of indecent exposure if he or she intentionally makes any open and obscene exposure of his or her person or the person of another, knowing that such conduct is likely to cause affront or alarm. Likely to cause affront or alarm. And then section B of this statute states that indecent exposure is a gross misdemeanor on the first offense if the person exposes himself or herself to a person under the age of 14 years. So it's clear that a lot of kids saw this display. But the question is, what exactly is considered obscene conduct? Well, there is a case which speaks about this. And the case is called State v. Murray. The court in that particular judgment stated that the statute does not define obscene. Obscene is defined in the dictionary as disgusting to the senses because of some filthy, grotesque, or unnatural quality, grossly repugnant to the generally accepted notions of what is appropriate, offensive or revolting as countering or violating some ideal principle abhorrent to morality or virtue. And then the court goes on to say that the court has also defined obscene as a lascivious exhibition of those private parts of the person which instinctive modesty, human decency, or common propriety shall be customarily kept covered in the presence of others. Now, the counter-argument by the defense attorney for this person, if he was charged, would say that, okay, he did have his, underwear on and he was not fully exposed, etc. But the statute does not seem to exempt that behavior, given the fact that he was in a provocative pose, dancing that way. And in addition to that, it appeared that the underwear was quite old and tattered. So it's not exactly clear what was actually visible. But anyway, either way, it's an utterly embarrassing and somewhat unappealing spectacle. And yes, that individual could be charged. He certainly could be charged. And this is what the Seattle statute and case, the Seattle Washington statute states. And the case law also defines the term obscene as well. So show support for the channel by liking, commenting, and subscribing.